Hi everyone, a warm welcome to all of you. Thank you very much for joining today's webinar on intellectual property protection in China. Intellectual property protection is a very important topic for startups doing business in China. It is a crucial factor for the internationalization process of your business, and a proactive preparation, like a proper IP strategy can help prevent violations. So I'm really excited to be part of this initiative today. And this webinar is a collaboration event between TechCode Germany and the China IP SME Helpdesk. So I would really like to thank Alessandra Caprilia from the China IP SME Helpdesk for reaching out and organizing this great event. And I'm really looking forward to Michal Klaczynski, who will talk about IP protection in China for European tech startups. So a warm welcome to all of you, and I'm really looking forward to this event. But first of all, let me quickly introduce myself. So my name is Sinja Han. I'm the community manager of TechCode Germany. But what exactly is TechCode Germany doing? So TechCode aims to be the #1 address for technology startups and SMEs that want to enter the Chinese market. We are doing this support with our global innovation network, consisting of advisors and mentors, investors from all over the world. Also, we are supporting our startups in terms of consulting, and we regularly launch startup accelerator programs, pitch battles, and open innovation trips, as well as delegation trips to China. And yeah, to put it briefly, we are basically trying to answer the following 3 questions. Which location strategy is suitable for a sustainable presence in China? What new business models can I establish in the China of tomorrow? And how can I make better use of innovation dynamics in China? So this is in general the idea you can get from TechCode Germany, but I would also like to introduce to you our partner, Zhongguan Sun. But yeah, last but not least, oh, sorry, forget about that slide. So yeah, we also have a co-working space in the middle of Berlin, right next to Alexanderplatz. It's a co-working space. We have a lot of offices, and we aim to bring together Chinese and European innovators and entrepreneurs. So if you're looking for a co-working desk, if you're looking for a private office in the heart of Berlin, right next to the beautiful Spree, yeah, feel free to reach out to us anytime. And as I just said, I'd also like to introduce to you our partner, Zhongguan Sun. Some of you might have heard of it already. It's basically China's Silicon Valley. So if you're talking about this innovation ecosystem, you will soon realize that there's all kinds of internet companies and big universities, R&D centers, all concentrated in one place. And this is crazy, but this is how China works, basically. And maybe you have heard of Innovate, for example, as one example. It's basically a startup incubation street in the middle of Zhongguan Sun, that offers co-working spaces, offices, and so on. Zhongguan Sun used to be quite different in 1988. So 40 years ago, it basically was a computer software market, and a lot has changed since then. So after about 40 years of development, Zhongguan Sun turned into China's main technology and science hub. Nearby, you have all kinds of top universities like Tsinghua University, as well as Beijing University. Also, there are a lot of amazing startups evolving and developing there. Some of you might have heard already of SenseTime or Kuaishou. And also there are many of them, of course, some of them die as it's like in the startup world. However, some of them really manage to scale up. And some examples are Lenovo, Baidu, ByteDance, and yeah, so quite an interesting topic. And if you have more questions about TechCode Germany or Zhongguan Sun, our partner, feel free to reach out to us. We are currently also launching 2 startup accelerator programs. If you have questions about that, if you're interested in participating, then feel free to reach out anytime. And yeah, so much from my side. As I said in the beginning, a warm welcome to all of you. I'm really looking forward to this event. And yeah, now I'd like to hand over the virtual microphone to you, Alessandra.
Well, thank you very much for your presentation, and thank you for organizing this webinar with me today. I am Alessandra Caprilia, Project Executive for the China BSME Helpdesk. just very quickly about the webinar interaction tool that you see on your right side of the screen. To all the audience attending today, the webinar, please feel free to use the chat box to write down all your questions related to intellectual property protection in China. All the questions will be addressed after the presentation by our expert during the Q&A session. So allow me to share a couple of words about the Helpdesk. In a nutshell, it is a project funded by the European Commission since 2008, and it supports, advises European SMEs on intellectual property protection and enforcement when doing business in China. More specifically, mainland Hong Kong, Macau, and Taiwan, each of them having a different legal framework. So over the last 13 years, we have helped around 100,000 SMEs from European Union, but also from potential future member states like Montenegro, Serbia, Turkey, Bosnia-Herzegovina, and so on. So more in concrete, SMEs can write us through our inquiry helpline and submit any question related to intellectual property protection. And all entrepreneurs will receive a reply within 3 working days. And of course, every inquiry is treated confidentially in accordance to EU data protection guidelines. We organize trainings and webinars like this one, and we hope to resume physical events soon. Welcome to visit our website, which is packed with useful, informative material, such as jargon-free IP guides, regional fact sheets, case studies, and so on. And of course, our inquiry helpline and all our material are free of charge. Here are a couple of examples of material that you can find online. On the left-hand side, you can see the mainland China fact sheet, so the main characteristics of the legal framework of mainland China. And on the right side, a little infographic about protection of trade secret. So the China PSME Helpdesk is part of a bigger family of international IP helpdesk supported by the European Commission. That advise European companies on IP protection in different regions of the world, specifically Latin America, India, Southeast Asia, and Europe itself. Welcome to connect with us on social media, where we post about our activities and our new publications. So thanks everyone for attending this webinar today. It is my pleasure now to give the floor to Michał. Michał, I'm going to allow you to share your screen in a moment. And once again, a little reminder for everyone, please feel free to write down all your questions in the chat box and enjoy the presentation.
So a few words of introduction. I'm a lawyer, and I'm going to talk to you about the international / Chinese intellectual property regulations. A few words about myself. I'm a Polish lawyer educated in Poland, in the US. I have a degree from both of those jurisdictions or those countries. I also studied in China. I have some, I would say, significant experience in international transactional work, including a number of projects in China with some component regarding transfer of technology, licensing, contracts, manufacturing, distribution, etc. Feel free to drop me a question or to contact me through the China IPR SME Helpdesk if you have any follow-up questions, or if you are looking for any relevant sources, materials relevant to Chinese intellectual property law. As I mentioned, and as it has been clear from the invitation, we are going to focus for the next hour or so on the Chinese regulations regarding intellectual property or protection of the intellectual property in the context of a foreign enterprise doing business in China. First, few words like trying to map the territory, like what we are going to talk about. What are the intellectual property rights? This is perhaps quite redundant for most of you. You are aware of examples, or your work, your educational background, etc. would allow you to know, or would expose you to the knowledge and to the practice regarding intellectual property and protecting intellectual property. Just to sum up, we could point out to three main spheres of intellectual property, looking at what we are trying to protect. We would look into arts, and that will be covered mainly by copyright. We would look into science and technology, and that would be patent law, trade secrets, to some extent antitrust law and competition law. And we would look into market identity, and that will be mainly trademarks, to some extent copyright as well, and competition law. One thing that is very often overlooked and needs to be remembered is that in principle, protection of your IP rights is territorial. So you need to figure out how to protect your intellectual property within every country, within every territory where you are present, where you are active. In other words, having registered a patent or having registered trademark in Germany or in Poland doesn't really give you any protection in China or I don't know, Japan or Thailand. So you need to be very cautious about that. How you manage your intellectual property rights and whom you allow to have access to the knowledge that you are trying to protect, or to certain economic benefits coming out of the knowledge that you share with others. There is a debate over the last 200-300 years regarding whether intellectual property is something that is personal of nature, or is it something economic in nature. And you have kind of a split of the point of view or the opinions between American lawyers, or 19th century, early 20th century American lawyers, and thinkers and lawyers in Europe. So far, and I'm trying to make a point here. The point I'm trying to make here is that Chinese intellectual property is still developing, is still in making, in a sense. Usually, like 2-3 years ago, we would say that the predominant component of the intellectual property protection in China would be economic rights. The focus would be on the commercial side of the intellectual property, not really on the personal one. And suddenly there is I mean, maybe not suddenly, maybe that was something to be expected, but it was quite a significant development in the theory or the doctrine of Chinese intellectual property. Was a court decision, the Court of Appeals in Beijing, regarding film adaptation of a Chinese fantasy book. The book is called Ghost Blows Out of the Light, and the author is a famous Chinese fantasy writer, Zhang Muye, who sold the rights to adaptation to a film production company, and was very unhappy about how things turned out. In the sense, he was unhappy about what was done to the plot, to the characters, to the whole story. And since the movie was quite popular in China, he didn't like it. But the part that he didn't like was the changes that were done in the original plot and the nature of the characters and the points that the story was making. So he initiated litigation against the movie producer, claiming that even though his commercial interests were not infringed, I mean, he was paid for the license that he provided, and he wasn't deprived of any economic fruits of his work. But he was claiming that his personal rights, which are also covered by the copyright law, or by the concept of the copyright law, and those personal rights, they refer to his right as the author to the integrity of the book or of the plot, to the main themes or main topic, or how the story unfolds, etc. And the court of the first instance and the court of appeals agreed with the writer, and actually repeated the same, or not really repeated, but made the argument that was very much in line with his point, with his thinking, but also with the personal rights theory. So to some extent, I would say probably it's not going to make a huge impact on the on any industry in China, maybe on media and film production industry. But it's not very likely that it's going to make any impact on the foreign companies doing business in China. Nevertheless, it's very interesting to see that the intellectual property system that seems to be well established already could actually experience such a tremendous or fundamental shift in the underlying thinking, or in the underlying ideas. Now, another topic or another issue that is very often raised, or which has been raised over the last 30, maybe 40 years since the intellectual property concept was introduced into Chinese social life and Chinese law, was the claim made by some scholars, particularly by Professor William Alford from Harvard, was, and the claim is that actually modern intellectual property protection is a completely foreign concept in China, and it's not going to work. It's not going to work because culturally, like with the deep roots in the Chinese culture, copying or following others and using the concepts developed by others, using the technology developed by others, but also using the artistic expression from others is a way in the Chinese culture of showing respect. Now, I think that the time proved Professor Alford and other scholars who said, oh, IP doesn't really go along with Confucian culture or Confucian way of handling the society, that the time proved them wrong, that maybe originally IP, like protection of intellectual property, is a Western concept. But to the same extent, you could say that the market economy is a Western concept. And since one concept was adopted within Chinese society, and it seems to work well, then all other concepts which are helping to make the market economy efficient are also adopted, and they become the integral part of the Chinese law. So you might come across this concept or this thesis that or comments as that, oh, intellectual property doesn't work in China. Well, it doesn't work as well as in America or in Western Europe, but it works quite well. I mean, it works well enough for us, for foreign investors, for foreign service providers, foreign sellers, to benefit from it and to make use of it. Now, a few words that I wanted to share with you about the historical concept, historical context of intellectual property in China. That might be something that is quite not quite well known in our part of the world, where legal culture or presence of law in our everyday life or in our professional life is something that we don't really think about. It's something completely transparent. We just we just accept it without thinking about it, that everything is regulated by law, that the relations we have with other actors, with our partners in business, with our companies that employ us, with other institutions in the society, that there are rules that actually regulate those interactions. And it has been the case in China only for the last, I can't say few years, but few decades. I would say that the concept that's something that is quite obvious for us, for people who grew up in Europe, in my case, in Eastern Europe, in your case, perhaps in Western and Eastern Europe, so somewhere in between, or maybe it's just my experience that I remember the time when Europe was divided. But nevertheless, even in the Eastern bloc in Europe, the societies and even though there was no market economy, etc., it was quite widely accepted by the society that there are rules, and that those rules are codified, they are known, and you might have a number of inefficiencies within the legal system as it is, but there is a legal system. Now, the experience that your Chinese counterparts, your Chinese business partners may have, or the experience or the history of the Chinese society, is that such a phenomenon, such an idea that relations between business partners and relations between governmental institutions and the society are governed by some set of rules is quite a new thing. And this is quite important. It might sound to you as highly theoretical, as highly or as quite irrelevant to your everyday work. But if you think about it a little bit deeper, it translates nicely, or translates quite well into a number of phenomena in Chinese business culture that are quite foreign to us. So what I'm trying to point out here is that the modern legal system that we have in China is it started to be created sometime in mid 1990s. The first legal regulations ever, I mean not ever, because there was a legal system in the pre-revolutionary China that is pre 1949. But then there was a huge gap for almost 30 years. The first piece of legislation that was adopted in communist China was an act regarding setting up and functioning of the foreign Chinese joint ventures in 1978. So and that was required basically to attract, maybe not attract, but to make to introduce foreign investors into China and to slowly introduce market economy. So the Chinese government figured out that you need rules, you need some legal system to support business, or to support commercial activity. And very much the present Chinese legal system is the outcome of this very need of the observation that the communist government of China made in 1970s, namely that without a set of rules, you won't be able to attract investors, and you won't be able to attract Chinese companies or Chinese enterprises to turn into market economy, which, in the opinion of the Chinese leaders back in 1970s, was the way to go in the sense of that it was the best way to make the economy efficient. So what we all should have in the back of our minds is that the Chinese society and the Chinese business and Chinese authorities look at the legal system in quite a utilitarian way. So they like it, they promote it, they develop it, but they do it not because it's something that is that constitutes an integral part of their society, or they're thinking about what how the state should work, but only because it's efficient, only because it provides a framework for the market economy. And similarly, the intellectual property provisions of intellectual property law was introduced into Chinese legal system quite late. I mean, there were some basic rules back in 1980s, but in the modern, it's not still quite modern comparing to the American legal system or Western European one, but the current wide developed Chinese IP system was put in place only some 20 years ago because China was aiming or was trying to join the WTO. So again, it wasn't like, you know, internal intrinsic values being translated into the legal system. It was rather a condition under which Chinese economy was provided another opportunity. And that way of thinking, I mean, you might have observed it, maybe not. It very much depends on with whom as a Chinese business partners you're dealing. You quite often get to deal with engineers or you know, managers, lawyers who are educated in the US or Western Europe, and they are very much culturally similar to their counterparts in the West, but still, you know, the predominant social reality is that law is something artificial and contracts are something artificial, and you regulate the behavior of individuals and also behavior of business entities through customs or through you know, through customary rules and through you know, their relations with others. Through you are rather looking for harmonious relations within the society than observing the rules as the value itself. Of course, you know, the rules or the law works in a very similar way as in, you know, Poland or Germany. That if you are not satisfied with the behavior of your business partner and you do think that the behavior is infringing any contractual rights and obligations or any rights and obligations that arise out of, you know, applicable law, then you have ways to enforce the behavior. But what I'm trying to say is that this is kind of like a next step. Usually, I mean, culturally, in countries in which law is something that has been in place for hundreds of years, you don't really need to reach to the. I mean, sometimes you do need to enforce your rights, but you don't need the threat of enforcement to make others think that something they agreed to and they into a signed contract is something they should follow. Now, having said that as an introduction, so two themes: to be a little bit cautious about you know, how your business partners behave and what they understand from the contracts and how they look at their contractual obligations. And the second thought is that intellectual property is quite a new, even though it looks very modern and very well developed, it's quite a new phenomenon. So and it's subject to growth and to change in China. Also, you could observe that the level or the degree or the quality of the intellectual property system in China and the protection of intellectual property in China is much better now than it was 10, 15 years ago. So you can see continuous progress and a better environment for all of us to operate in China. Now, when you are entering a new market, when you want to you know, scale up or to a large market abroad, or you want to develop a product for that market, etc., you would be looking, and no matter where you go, you would be trying to look at your business, and you would be trying to identify risks. Like what is the type of presence you want to have in a given country? How do you need to interact with others? What are your goals? Are you going to reach out to consumers? Are you rather interested in B2B relations? What is the product that you're offering? Do you want to manufacture there and sell somewhere else? Do you want to manufacture in Europe and sell there, etc.? So you would be looking at, what do you need to protect? What is valuable within your company, and what out of that is valuable you want to make available, accessible to others. And then you would be, and it's good homework to do it before you actually start operating in China. And you can avoid a number of of early commerce mistakes, like not having something registered, not having something protected, being too open with the partners. So if you're thinking about technology, and that you think your technology is prone to reverse engineering, for example, then you don't really have much choice, and you need to apply for patent protection of your of the devices, the manufacturing methods, etc., that can be protected under patent law. If your technology is not really prone to or sensitive to reverse engineering, then you might want to rather simplify your business model and think about keeping certain parts of your technology, of your processes as secret, and rely on the trade secret protection and the competition law protection that covers you in China. If your main concern is your market identity, is that your brand is known, it's not mistaken with other brands, or it's not counterfeited. Your products are there's not much of you could actually qualify for a patent, but you believe that that's stating that your products come from Western Europe, that it is it has a known brand, and the brand transfers some notion of quality or a specific features, then trademarks will be your main interest. And I would say that those are two most important areas of intellectual property law: trademarks and technology protection, including patent and trade secrets. You will have some others, some other things to look into. I would say that the copyright law is probably the least important for you, and unless you are in the industry that that somehow deals with art, media, literary works, film, etc. Then you what you are putting on the market will be protected under copyright law. What there is I mean, it's still worth understanding the basic principles. So you have a number of as I said, it's a mixed bag in China. You would have so-called fields of exploitation of protected rights listed in the Copyright Act. That's an enumerative list. Those are also fields on which you can provide license to others. What is special about Chinese copyright law is quite a wide role or important role of fair use, so that others can use the copyrighted work without your consent, or without you providing a license. It's worth to look into those and to see those as limitations of your exclusivity in terms of copyright law. With one more remark about copyright is that it's quite unusual worldwide, but the practice, and it's not and it's not a condition for obtaining a protection in China. But the widespread practice in China is that you register your copyrighted works with the authorities, and you do it basically for having much easier case when you want to prove that actually something is yours. or some piece of work is developed by you. What is interesting, computer programs are copyrightable, are protected by copyright, and they are copyright. But you know, this protection is not that useful if you think about it, because only the literary part of the software is protected. That is the way you express ideas in a particular source code. So you can't really protect. You can't really have copyright protection for the for any more general components of software, like functionalities, like the algorithm, like the way the software operates. So you know, you might say that you know, copyright protection of computer programs is not very useful. Now, turning into trademarks, what is really worth mentioning and worth focusing on is that that China is one of the very few jurisdictions in the world that gives protection to the one who was there first. So if you use your, and I've seen from a personal experience, I've seen cases like that. I've been you know, advised a Polish client on a very typical problem with trademark, where their business partner in China actually registered their trademark, and then you know, in this case we were able to argue that they registered the trademark, you know, for the benefit of their Polish partner. But what you're really afraid of is that someone who expects that you would be entering Chinese market is registering the trademark to make your life more difficult. And this is legal in China. This is allowed in China. There are some ways to invalidate a registered trademark, but this is not very easy. It's seen as one of the most unfair issues and one of the obstacles for the proper protection of you know, foreign business in China. We will have a case study later on, so I'm not going to dwell on this issue now. So as the first to file protection, like is one thing. The other thing is that it's very typical for China to localize the trademarks, to make them basically Chinese, to make them easy for the Chinese customers to use, to pronounce, to write down. And you have a number of ways, great ways, not so great ways, of translating your trademarks, translating your brand names, or translating your market identity, your brand identity into Chinese language and culture. And usually what you would be looking for is something that sounds a little bit like the original brand, and where it has a good meaning. Good meaning in the sense that it is easily connected. The perfect case is like that, you know, the meaning of the Chinese characters that are used for your brand, that they sound similarly to your brand, or somehow resemble the original sound, but they also have a meaning that is at least neutral, and preferably which is good, which tells something interesting about your brand, which attracts you know, attracts to your brand. And I put together a number of examples, and they're quite different. You can see, for example, that you know, Apple, the computer company is called in China Pingguo, and they rely on the visual part of their brand identity, that is the Apple, and they just translated. They just used the common word Apple for their identity. It's not perfect, but if you think about it, and you know, perhaps the connection that you have in your mind between the brand and their name is the, you know, the shape of the apple with the you know, with the bite on the side. and perhaps there was no better way to translate it, or to deviate from the, it would somehow dilute the idea. Now, one of the nicer or like well done brands are BMW. It's called in Chinese Baoma, which means like a precious or yeah, horse. But this horse, it sounds, this ma is a horse in Chinese. It sounds a little bit awkward for us when you talk about a car. But actually, a vehicle or something that is used for riding or driving is very much until these days, like the connection between a horse and a car. It's quite an obvious one in China. So it works quite well, and it adds some some nice connotation to the brand name. When you look at the Siemens, it's Siemens. The meaning is quite awkward, right? I mean, it doesn't really say anything about the brand. It's just a Western gate, but it sounds very nice. It sounds very close to the original brand name. One of the greatest or the best examples are Coca-Cola, where you can see that both the graphic translation of the brand and the sound are quite good, quite closely resembling the original one, and also the meaning of those are quite maybe not well, the meaning somehow relates to the emotion that you want to raise, or the experience that you want the customers believe that they will have while drinking Coke, and that it's like something tasty and something that brings joy. Another another tool for protecting of the market identity are geographical indicators. You might want to, or let me put it this way, usually European products are considered to be luxury ones, and you might want to explore that notion or that connection that most of the Chinese customers have, and you might want to underline that something that you are bringing to China and selling there is of European origin, and it's a traditional product from some part of Europe. And then the Chinese legal system offers you an option, opportunity to register a geographical indicator. It's not exclusive in the sense that it's not exclusive for one company. It needs to be registered for as a collective mark, that all the producers, for example, for some region or product coming from some region can use it. Inventions, again, first to file jurisdiction. The Chinese Patent Office is one of the most active ones in the world. It's second after the American ones. China is also, it has been for the last 15 years or so, the country where the second biggest amount of public investment in research and development was used, and that translates very much into the number of the patent applications within China. Those are mainly Chinese patents. Also, Chinese inventors or Chinese technology companies are becoming more and more active abroad, and they are patenting their technology in the EU, in the US, and other major markets. There are still complaints about the quality of the patent procedure, but how formalistic it is, how much it's based, or how much it's maybe not unfair is like saying too much, but how much more difficult it is for foreign technology companies, because it relies very much on the description in the Chinese language of the technology and on the right translation. So The process has a reputation of being very difficult, of being quite long, and of a number of technology companies being unsuccessful due to some clerical mistakes or mistakes in the translation or quality of the translation. The patenting in China works like everywhere else, that in exchange for exclusive use of your technology, or exclusive use in the sense that you decide how to sell it on the market and to whom allowed to use it, and in this respect you have the exclusive right. You disclose, you make a full disclosure to the public, so your technology is becoming known. Now, if you have patented something somewhere else, then it's also like if you file the patent application in the US, and then your patent file is available to the public, then it doesn't make sense not to file a patent application in China, because if you don't do that, and then your competitors have access to the patent information somewhere else, then you might be deprived of any protection in China. So you also need to think about kind of maybe not international, but maybe not global, but a comprehensive strategy of technology protection. Another good way of protecting technologies is through trade secrets. And actually here, it's the very much reverse of the patenting, that you actually are obliged to keep things secret if you want them to remain secret. So you don't do any registration, you don't disclose anything, there are no time limits for protection. You need to make sure that either from technical perspective, like reverse engineering is not going to help, and that you very much control the access that others have to your technology. So, and this is actually a prerequisite under the Chinese anti-competition law, that if you want to keep something secret, if you want to use the trade secrets protection, then you need to actually show, you need to demonstrate that you made the effort, both on the technical side or factual side, like access to your factory, access to the documentation, etc., and from the legal side or contractual side, that your employees, your partners, they actually sign agreements that cover their obligations not to disclose it, not to circumvent the protection, not to compete with you. Right. This is somehow connected with the trade secrets. Usually something you're familiar with, like the non-disclosure agreement, with the standard scope, and the standard scope being that the third party that has access, that gets access to your confidential information, is obliged not to disclose it. You might want to add to that scope of obligations some other obligations, like that the third party is obliged not only not to disclose, but also not to use it, not to compete with you. You don't want someone to gain knowledge about your, I don't know, industrial process, your production methods, or your marketing methods, or anything that actually makes your product, or makes your company more competitive on the market. You don't want your partners to be using that very knowledge in building a product or a company similar to yours. This is a development only coming from the last few years. You have quite a strong protection of online IPR infringements. It's mainly regarding counterfeited products in the context of e-commerce platforms. Basically, the Chinese legislation brought a concept of the platform owner or platform manager to be responsible for IP infringements, and that very much changed the landscape. Right? If you are an owner of an e-commerce platform and you are responsible for infringements that actually is an incentive for you to put together some sort of mechanism to trace counterfeited products, to exclude them from your platform, and to cooperate with authorities. And it works quite well. Now, whenever we are talking about, one part of your thinking about intellectual property protection in China is like, what do I need to do in order to register, to make sure that my IP is mine? Now, even if you have your trademark registered, even if you have your geographical identification certified, even if you have your patent application filed, still you might be subject to infringements of those very rights. And then the question is like, what do you do? And then for business people and for lawyers from the West, from Europe, for example, the most obvious answer would be, I go to court. I sue them for damages, and I ask the court to prevent them, to order them not to do something. And those tools are available in China, but they are not very effective. One part of why they are not very effective is that culturally, Chinese society is not very litigious. It doesn't, and that comes very much to the concept, or to the notion that I mentioned at the very beginning, that the whole legal system is quite a new phenomenon, and that relying on courts ordering others to behave in a certain way is not traditionally something acknowledged or accepted in China. Of course, you might have a court order preventing someone from doing something, but it will take time, it will take effort, and you will go through complicated procedure in Chinese with Chinese lawyers, and you will be very disappointed as to the part when it comes to the damages. So part of not being a litigious society is that the Chinese legal system, or legal scholars or judges, they don't really believe in the, as opposed to the American system, for example, where they think that the economic incentive, like if you're obliged to pay damages for what you've done, is the best way to educate society. That thinking is not really present in China. So you will have very low, like, nominal damages, if at all. What you will end up is like having a court injunction, a court order preventing the other party from doing something, but you might be a year or 2 years away from that moment when you actually file a claim. What works much better, and what is, I think, specific for China, unlike Europe or the US, is the criminal enforcement, criminal measures, and the administrative enforcement, and that too very much relates to the notion of the of Chinese society being used to being managed by authorities. So they are not really the idea that horizontal relations between equal partners, subjects of like entrepreneurs, business partners, that they deal get sour and they rely on the resolution by the court, where they are equal, is not something traditionally present in Chinese society or Chinese legal culture, as opposed to the idea where the law is very much connected with the relation vertical between the authority, or between the prosecutor, between the criminal authority and the subject. Now, you have quite a number of different governmental agencies which are allowed to intervene, which are not really allowed, but in which case it's the scope of their job, or it's the scope of their entitlement to intervene in or to regulate the intellectual property. And some of them might be quite surprising, like the administration of quality supervision, inspection, quarantine. They are very useful, and they are very effective in tracing trademark infringements, counterfeited goods. And they will do much of the job for you. If you can prove that the counterfeited goods are offered, and you file a claim, they would prosecute the infringing party on the basis of the counterfeited product, like using someone else's trademark is making is misleading consumers. You would have customs office which regulates also the export from China. They have quite wide competencies to seize products which are going to be exported from China. It might sound a little bit awkward to us, where customs are rather about protecting the internal market and not regulating what is exported from a country. But it can prove quite useful if you're, for example, manufacturing something in China, or you see that your product is counterfeited in China and then offered somewhere where your trademark is not registered, somewhere in Asia, Central Asia, Africa, etc., where you didn't think about it. And if you have your trademark protected in China, then you can enforce the protection there. So I would say administrative and criminal part is much more useful, much more sensible than the civil litigation. I have a few case studies, and I will go quickly through them, perhaps allowing you to ask some questions when I'm done for the last few minutes. So the first one is about trademark protection and how tricky can a Chinese trademark law end up. So you have basically a company which wants to sell counterfeit products. I mean, they are not original New Balance products, and then they register a trademark, and then which means actually New Balance, Sipailu, and then New Balance is deciding, okay, fine, we are going to operate in China under our original trademark. It ends up in a catastrophe where the owner of the original trademark, well, the original trademark abroad, is prevented from selling their own product because someone else registered their trademark and started to use their trademark, started to sell footwear using the trademark. You are prevented to sell your shoes, and you need to pay a penalty for doing that before. So what is the lesson learned? One lesson learned is that China should change their trademark regime in this respect, because it's abusive. It's very clear that it's abusive. Even if you make your way in court and invalidate a competitive trademark, for example, because there's like a obvious bad faith, the trademark wasn't used for 2 years, etc. It's not that easy, and usually it's just this very regulation allows kind of ambush, or kind of like a blackmail, that you are a European company coming to China, you didn't register your trademark, now you are approached by your competitor who either wants to benefit on your reputation abroad because your product is known, or who just want to ask you to buy your trademark from them. You might be I mean, this is one option. The other way to deal with such a situation is to think about rebranding, because anyway you are going to reinvent your trademark for the Chinese market. You are going to translate it, and you might want to translate it in a different way. You might want to translate it in a different way than your competitor. It could be worth to do some work and think about how to what can I do if I don't want to negotiate with a terrorist. The second case study is about in online e-commerce infringement, and actually a case of mystery shopping done by by the online platform owner and manufacturer of certain product. In this case, it was pet food. It's quite, you can see the scale that those are thousands of notifications that are issued by Alibaba to the law enforcement agencies, and you see that it translates into shutdown of a number of manufacturing facilities, in criminal liability of a number of people. And you could see that this very regulation is going to change the landscape of the e-commerce platforms. Yet another study is about a 3D trademark being useful. So, like, you can obtain a protection for a trademark that is a three-dimensional shape, and based on that, you can. It's kind of like a, I would say, backdoor, or maybe not backdoor, but it's a parallel way of protecting packaging. If you treat a special, package of your product as a trademark, so you can register the 3D one. One of the most important developments in Chinese law and related to IPR is the antitrust law. It was a big missing part of the puzzle, I would say. So China is like a latecomer if it comes to antitrust and unfair competition. They introduced their first antitrust regulation only in 2008. So after some 20 years of debating about it, so they, on one hand, they joined the, if you are thinking about M&A market worldwide, you have a number of like a big antitrust offices, like European Commission, US antitrust office, but also Japan, Korea, where if you are dealing with a multinational merger, then you need to file notifications of the merger, and you need to wait until clearance from the antitrust offices. So China is becoming one of those, as most of the multinational companies, they have actually the level of the notification is triggered in China. But also there are more and more interesting disputes regarding compulsory licensing, regarding technology, and they are resolved by Chinese authorities and Chinese courts. And this is one of those where Huawei was successful in obtaining a court order imposing an obligation to disclose certain technology to Huawei, to a Chinese company from an American one. This is quite on one hand, it's quite maybe not inconvenient, but quite threatening that you might be enforced. So the basic principle is something that we know from other jurisdictions, like it's not very common, but nevertheless you have this option both under the EU antitrust law and also in the US. It was quite surprising, though, that such a sophisticated line of litigation was introduced in China. So I don't know to what extent it could be relevant to your daily business, but nevertheless, you should also have in the back of your mind that antitrust law, competition law, is a growing field, a growing branch of Chinese law, and you need to be aware of that. Takeaway messages like prevent infringements. So this is the first thing that you can do. Like sit and think about the what is typical, what is special about your business case, what you want to do in China, what components of your business identity do you need to protect? How can you do that? Is it technology? Is it the market? Is it the market identity? Maybe it's both. Register the trademark, localize the trademark. Be sure that you are dealing with trustworthy partners. This is something practical, and it's a practical advice anywhere you go. I think if you're a foreign investor, anywhere in Europe as well, you don't want to lose your time, and you don't want to be in a position where you disclose some sensitive information to a partner who is not trustworthy. Avoid litigation unless it really makes sense, or unless it's the only way forward for you. Try to cooperate with the administration, with the authorities, with the prosecutor's office, etc. In case of infringement, monitor the market, like try to detect that the product that is similar to you, that stolen technology or counterfeited products are showing up. Use different ways to protect the same assets, the same IPR rights, and manage confidential information. Like make sure that there are procedures within your company regarding physical access and right to access certain things. Try to compartmentalize your production. If you don't have to manufacture everything in China, manufacture it in Germany or somewhere else where you have a better control over the process. Maybe some key components of the product can be imported to China and can be then assembled there. Maybe you don't need to rely all the information to one supplier, etc. Party reading. There's a number of good books in English about Chinese intellectual property. Those are 4 that I could recommend. They're quite new. They were published within the last few years. You can get hold of them easily on Amazon, or I guess on in any German library. I think this is a little bit redundant because like the presentation of the help desk was already done by Alessandra, but maybe you have some questions right now that you would like to ask.
Thank you very much, Michał, for your presentation. It was quite insightful. We do have a question here. So what is the range cost for registering an invention patent? And do I have to register in both Hong Kong and mainland China if I want, if I'm starting from Hong Kong?
What do you mean that you're starting from Hong Kong?
I guess,
yeah.
Yeah, sorry, go ahead.
I think you need to look into the picture and see where you are going to put your product on the market. So it doesn't really matter where you are manufacturing it or which channel are you going to bring it to China. So if you manufacture it in Germany and you bring it to Chinese market through Hong Kong, it doesn't really matter, because what you want to prevent is a situation where where a product using your very own technology is being put on the market in China. So China will be your key jurisdiction in terms of obtaining patent protection, and it's sufficient to have the patent protection in China, unless there is like very particular additional utility of being covered somewhere else on the way. The overall costs very much depend on the translation costs and the fees by the trademark patent attorney. So the main driver of the costs will be the difficulty and the length of the proceedings. It shouldn't cost you more than a few €1,000, maybe 10, maybe 15, but it should really cover all the expenses. The fees, the official fees, are not very significant. Those are few hundred euros in case of a patent application. So I would say that you probably need to get in touch with a reputable patent lawyer in China and figure out what you want to patent. Maybe you can somehow limit the scope of the disclosure that you're making. Maybe you can patent only key part of your technology. You need to look at the cost of translation also. But in any case that you are, I think if you decide that the patent protection brings you an economical benefit, like providing you with a protection on the market that you want to deal, then like the costs are it's very much black and white. So if the patent protection is the only way you can protect your technology, then you need to do it, regardless of the cost. But the costs are not going to be massive. It's not going to be, it's kind of like a random guess by me. But I would say that you shouldn't exceed 10,000–15,000 euro.
Okay, and follow-up question is, how long does it take to register a patent?
Again,
more or less.
More or less, I would say you should count a year. I think minimum, like 6–9 months would be like simple case and a quick procedure. I would count a year or longer. But the beauty or the beauty of the situation is that once you file the application, then you are protected in a sense. Then I mean, unless you granted the patent by the end of the day. But you can assume it is in your interest not to do it right away, because then if there are two competing patent applications, the one that was filed earlier will be granted priority. And yeah, I don't know if I answered. I kind of like answered the question that you didn't ask, but I would say, roughly speaking, a year to a year and a half. You should count for the patent proceeding in China.
All right, thanks a lot. I don't see any other question, but please feel free, everyone, to drop us an email if you have any question in the future. Thanks a lot, Michał, for being with us and to share your expertise. And thanks, Sinia, for organizing this event with me. I wish everyone a very good day, and we'll see you next time.
Thank you very much.
Bye-bye.
Thank you all so much. Take care. Bye-bye.
Bye-bye.